Thank you. Thank you, Madam Speaker. Madam Speaker, the protection of industrial property rights in Mauritius is not new. We've been having laws to protect patents, copyright, trademarks for well over a century now. The Trademarks Act was enacted as far back as on the 1st of November 1868, 150 years ago. The first Patent Act followed suit and was enacted on the 22nd May 1875. The Copyright Act came much later in 1997. But really it is in 2002, under the MSM government, that the law on industrial property was completely revamped for Mauritius to meet up with its international commitments, namely the trade-related aspect of industrial property rights, commonly known as TRIPS, and our commitment under the World Trade Organization. There were 4 pieces of legislation enacted in 2002: the Patent, Industrial Design and Trademark Act, the Layout, Design, Topographies of Integrated Circuits Act, the Geographical Indication Act, which unfortunately was never proclaimed, and perhaps more importantly, the Protection Against Unfair Practice Industrial Property Rights was enacted. I say perhaps more importantly because that piece of legislation was revolutionary, because for the first time it allowed well-known marks to be protected in Mauritius even if they were not registered. And soon enough, after the new piece of legislation was enacted, it was put to the test in the Ralph Lauren case, or the Ralph Lauren cases, if I should say so. That was the case, Madam Speaker, you would recall, where a lot of local manufacturers in Mauritius was in factories having apparels of Ralph Lauren, so they were selling and passing off as a genuine Ralph Lauren product, and many tourists fell to the trap. So Ralph Lauren came and brought proceedings in Mauritius, and in a landmark decision, Mr. Justice Lam Shan Ling, after referring extensively to the Hansard, held that the intention of the legislation was to afford protection to well-known names, even if they were not registered in Mauritius, and accordingly, Mauritian manufacturers were not allowed to manufacture a product with the Ralph Lauren polo label without the authorization of the trademark owner. And the rationale for protecting industrial property, Madam Speaker, is aptly summarized by the learned judge as follows: no person must be allowed to steal and reap the fruits of those who, through their skills, judgment, expense, and know-how, had created a work which seemed to appeal. So, Madam Speaker, there is a long-established practice in this country to protect industrial property, and this bill has the same philosophy behind it, which is to consolidate the right of inventors, the right of people who has come up with an imaginative product to get the protection. This bill is interesting because it extends protection to certain type of intellectual property that was not previously covered by the existing legislation, namely utility models, layout designs of integrated circuits, breeders' rights, and plant varieties. The bill also protects products which have specific geographical origin, like the Honourable Minister mentioned, like the limon de Rodrigue or the other canne à sucre de Maurice. And I really hope that these provisions relating to geographical origin will not suffer the same fate as its predecessor, because if you will recall, Madam Speaker, the Geographical Indication Act, which was enacted in 2002, was never proclaimed. Madam Speaker, of particular interest to breeders would be the protection that will be afforded now to breeders who have come up with a new variety of plants. Under the existing legislation, plants and animals were expressly excluded from the protection of patent. And in fact, even under this current bill, Section 10 still excludes plants and animals from patent protection. But there's a whole new section, Part 5 of the bill, devoted to the protection of new plant varieties. Breeders of new plants will now be able to protect plants, provided the plant is new, distinct, uniform, and stable. This is in section 55 of the bill. Now, the obvious advantage of protecting new plant or variety is that the exploitation of those variety would require the prior authorization of the breeder. This is definitely a welcome decision for all those researchers, especially in the cane industry, who has worked on improving our sugarcane, making it more resistant to cyclones. But not just sugarcane. The Honourable Minister for Agriculture mentioned earlier today, answering to a PQ, how we are developing new seeds for potato and onions. So it's important that those people who spend time and research and develop these new varieties which are resistant to climatic changes, resistant to pests, be having the protection afforded by the law. And with the challenges facing the cane industry, Madam Speaker, it is important that we need to diversify. Our land is limited, so we need to make optimum use of our arable land. We've been talking about cane, but there may be scope for the development of a kind of a variety of plant which is high in fiber. And this plant will then be used to generate renewable energy through biomass. Now, once the inventors come up with this special high fiber variety of plants, they would want to have the protection of the law, and probably they would want to be able to export that technology, that know-how, that variety of plant to Madagascar or Africa or other countries. So the potential is there, Madam Speaker. But a word of caution. A word of caution because the Act extends protection to nationals of a member of the Union for the Protection of New Varieties of Plants, UPOV, founded by the International Convention for the Protection of New Varieties of Plants. Now, Mauritius is not a signatory to that convention, International Convention for Protection of New Varieties of Plants of 1961. And yet, what we're doing today is affording protection to any person who is a member of a state which is signatory to these UPOV. And, Madam Speaker, the Honourable Minister did not explain why we are now going to implement the UPOV when we are not a signatory. So I don't know if we have already negotiated what are the stage, whether we have signed the... We certainly have not signed because it's not on the website, but I don't know if there's been any application made by Mauritius to become part of the convention. But if we have made this application, then a big word of caution. Because many civil societies around the world has criticized UPOV as being detrimental to small farmers. In fact, the main criticism is that instead of protecting plant variety, UPOV end up protecting the interests of large plant breeders and biotech companies. I'll give an example. In Mauritius, many small farmers who have flower plantation or vegetable, they import seeds. So when they import those seeds from abroad, they pay a royalty to the person who has come up with those seeds. But once they have planted the flowers and the vegetable, usually after the first harvest, they would collect some bouchure which they will use again for the next harvest. And sometimes they will even exchange it with other farmers to get new breeds, and sometimes they would even sell those breeds. And this is totally acceptable because they've already paid for the seeds, and what they are doing now is recovering their investment. But unfortunately, Madam Speaker, if we ratify UPOV, each time we will reuse that plant. Even after the first harvest, we will have to pay a royalty to the original, the owner, the original breeder who came up with this variety of plant. So I don't know how much research work has been done at the level of the ministry or the IPA office to see what the cost benefit of adhering to UPOV. But if we do decide to go and ratify the UPOV, then I will ask the Minister to make sure that we have sufficient reservations to the Convention to protect the interests of our local farmers. Madam Speaker, although generally we are in favor with this bill, with the content of the bill, there are three aspects of this bill where we have reservations. The first one is the Intellectual Property Council, which is being set up under Section 7 of the bill. Now, this Intellectual Property Council will consist of 14 members. There will be 14 members, and their primary duty would be to advise the Minister, it would be to advise the Minister on, if I can get that in my notes, on any matter relating to intellectual property and ensure coordination among the public and private sectors in the formulation of intellectual property policies and enforcement of intellectual property rights. Now, we are putting a council with 14 members who will be paid such remuneration as the Minister will determine, which will consist mainly of civil servants. And my question is, do we need such a council? We are already signatory to many conventions. There's already a department in the Ministry of Foreign Affairs dealing with intellectual property. We already have a second secretary or first secretary in Geneva full-time looking after all these conventions. So why have this council? The more so when we are providing for the creation of a new industrial property office in Section 3 of the bill. And funny enough, the object of that office is to assist in the protection, promotion, and development of industrial property governed by the Act. So already this office is going to do what the council is supposed to do. And the office will have a director, a full-time director, a full-time staff. So we have really serious reservation, Madam Speaker, as to la raison d'être and the justification of having a full-time council set up of 14 members. The second reservation that we have on the bill relates to the Madrid Protocol. The Madrid Protocol relates to the Madrid Agreement concerning international registration of mark adopted in Madrid in 1989. There's a whole new section about Madrid Protocol in this bill. It is in subpart D of part 7 of the bill. Let me point out from the outset, Madam Speaker, that Mauritius is not a party to the Madrid Protocol. Yet we are being asked to vote a bill to give effect to a convention, a protocol, to which Mauritius is not a party. Now, if today an international trademark owner wants to register its mark in Mauritius, let's say Adidas wants to register its mark in Mauritius, what it has to do is he has to appoint a trademark agent or an attorney in Mauritius to do the necessary filing with the Industrial Property Office in Mauritius. So the local staff, the trademark agents, and the attorney go do the search, make the application, get the registration done. With the Madrid Protocol, Adidas will first have to register its mark with its local IP office, which is in Germany. And then its IP office in Germany will make an application for international recognition to an office of WIPO, Intellectual Property Office, in Geneva. And when they make this application for international recognition, they will indicate which countries they want this mark to be recognized. So if, for example, Adidas wanted to be recognized in Mauritius, they won't have to come directly to Mauritius. They will just file the application through WIPO. WIPO will then contact the Mauritius Intellectual Property Office, and if there is no objection, the mark gets registered. So obviously, what we're doing here, we are bypassing all the local trademark agents and all the attorneys. And when the bill was circulated, or rather an earlier version of the bill was circulated, there was consultation, and a letter dated 30th of January 2017 was addressed to the Ministry of Foreign Affairs and Regional Integration and International Trade by several, at least 20 registered trademark agents and attorneys, including senior attorneys. And in that memorandum, they consider Madrid Protocol. They consider all the advantages that we will get if we adhere to Madrid Protocol, but also all the disadvantages and drawback if we adhere to the Madrid Protocol. So they have I'm not going to go through all the advantages and disadvantages, but I'm just going to read what was their conclusion. As a matter of fact, as at date, the ministry or the WIPO representative has not demonstrated with the support of figures that Mauritius, including the trademarks agent and attorneys, will gain if the country gives effect to the Madrid Agreement and Protocol. And then they go on to state, out of 200 trademarks applications made monthly, approximately 80% of such applications are submitted by trademark agents and attorneys. In case Mauritius adheres to the Madrid Protocol, there will be most likely in a very difficult situation leading to job loss. And therefore, the implementation of the Madrid regime will bring more, that the implementation of the Madrid regime will bring more work to Mauritius is illusory, having regard to the reason given above. And they conclude, we therefore earnestly request the government not to give effect to the Madrid Agreement and Madrid Protocol. So these are our experts in the trademark sector, well-known senior attorneys and trademark agents, making a plea to the government not to enforce, not to ratify the Madrid Convention, the Madrid Protocol. And in fact, listening to the Honourable Minister, I'm also not convinced, personally, that it will be in the interest of Mauritius to ratify the the Madrid Protocol. So I don't know if, again, if a study has been made to assess what would be the impact of ratifying the Madrid Protocol, especially in terms of the job losses for trademark agents who will become obsolete if we adopt the Madrid Protocol. But the real cause of concern, Madam Speaker, that we have with this bill is the restriction on parallel imports, what the Honourable Minister referred to as national exhaustion right against international exhaustion rights. As the law currently stands, anyone who wishes to import any registered mark requires the consent of the owner of the mark. Now, it is very important that we bear in mind that we're not talking about counterfeited products. We're not talking about illegally importing goods that are being passed off as branded goods. We're talking about importing genuine products. Genuine products, whether it is apparel, designer shirts, designer suits, designer shoes, whether it is cosmetics, but even toothpaste, even toothpaste or foodstuff, the chips that you like to eat, equipment, computers, cameras, branded goods, all these genuine products, we can't import them in Mauritius without the consent of the owner, the registered owner of the trademark. And I'm repeating it because generally in the mind of the public, as long as it is genuine, we should be able to import. What is prohibited is counterfeited product. But if I'm going to South Africa and I'm able to import spare parts of a car which is cheaper than what I can get in the local market. And if it is a genuine spare part, why can't I import that? Surely it is for the benefit of the consumers that we are able to import genuine products. This will increase competition among trademark, among dealers in genuine products. And the trend everywhere in the world is to allow the import of, what we call parallel import, allowing genuine products in the country of, where they are, provided that they are genuine. What is the logic? The logic is when the trademark owner has put the product on sale, he has already received his royalty. So when, for example, Nissan decide to sell his spare part to a distributor in South Africa, Nissan has already received royalty from that South African distributor. Now, what is the harm for a Mauritian importer to go to South Africa and buy these genuine products if they are cheaper than in Mauritius? But that's what exactly happened in Mauritius a few years ago. One of the dealers in spare parts in Mauritius decided to bring a container of Nissan parts. Why, Zario? Why did he do that? He did that because a lot of owners of cars were having problems getting spare parts. Why? Because the agency, what we call l'agence, the registered distributor, when he imports spare parts, he keeps a very small, tiny stock of spare parts. And he will take spare parts for only those cars that he is selling. But what about the second-hand cars that are imported? When those second-hand cars that are imported, the Nissan, or whatever make, Subaru, Honda, when they come to Mauritius and they break down, they need spare parts. When they go to l'agence, l'agence not only take them months before giving them a spare part, but the price that they charge, you can't say anything. You're obliged to buy it at whatever price they want to pay. They ask you to pay. So one of these importers, Zario, decided to import the spare parts. And he came to Mauritius, and the custom blocked the spare parts. Nissan, the registered owner, brought proceedings in Mauritius. Again, Mr. Justice Lam Shan Ning was the one sitting on that case, and he said, no. The effect of the law as currently drafted in 2002 with the passing of Unfair Practice Act and the Patent Trademark Act meant that you could not import even genuine product without the consent of the owner. And I have to say, I'm sorry, but this situation is being exploited by a lot of unscrupulous agents. You know the number of times I receive a call because the custom has seized goods, genuine products, apparels, and then you know what we have to do? We have to go and beg the owner, the registered owner's agent in Mauritius, and then they charge us. Okay, we'll allow your client to remove his goods from customs, but you have to pay us X amount of money, which very often is more than the actual profit that is expected to be done by the sellers. And it was not just Nissan. We had the same thing with Ralph Lauren. Same thing, this issue, which was decided on the same date. And what is more than speaker is that the person who acted for that importer was being prevented from importing Ralph Lauren product is a senior counsel who is now in cabinet. He's in this government. He pleaded the case. He pleaded the case. He had well pleaded, very well argued that you needed to allow parallel import because the trademark owner has already received his due. There's no sense in preventing him from importing. But why is it then when the bill comes to cabinet that senior counsel keeps quiet? He forgets all that, all that he has pleaded in court, all the advantages for the consumer. Because at the end of the day, Madam Speaker, what we're doing is making a choice. Either we are in favor of consumer, or we are in favor of the distributors in Mauritius. So either we are les peuples, or we are with the rich. So the choice is clear. The choice is clear because the TRIP agreements does not tell you one way or the other whether you should allow or restrict parallel import. It is left to every country to decide for themselves. Madam Speaker, the Honourable Minister knows that this is a sore issue, national exhaustion against international exhaustion. I have referred to cars, spare parts, I have referred to to apparels, but the same logic applies for pharmaceutical products. Today you have big pharmaceutical products who, because they have invested a lot in research and development, once they come up with a medicine, a cure, they obviously put a high price tag. It's okay. But once they have already sold it, they've already recouped the investment. Why are we prohibited from importing those medicines? A survey was carried out, a report was carried out in Africa on HIV. And the report showed that the fight against HIV in many African countries would have benefited greatly if these countries had adopted an international exhaustion of rights, which would have allowed them to import HIV drugs sold in India at low prices. Because the government chose to have a restrictive application, the national exhaustion right, banning parallel import, because of that decision, millions of people in Africa have been suffering through inability to get generic drugs. And today, when we have a chance to change the law, to learn from our mistakes, we are using again the national exhaustion. Why? Because no doubt, lobby from the private sector. We know, I have seen the report from the Mauritius Chambers of Commerce saying that no, we should have national exhaustion rule. We should prevent parallel import. Yes, because they benefit. They make millions of profit every year at the expense of the consumers. Obviously, they won't want to have a liberalized economy where import of genuine products are allowed. Madam Speaker, where I'm really surprised is that the Honourable Minister refers to a consultant who has been retained by Mauritius to assess the socio-economic impact in the event Mauritius adopt an international regime for exhaustion of trademark. He mentioned that this report is funded by the European Union, and he went as far as saying that we are now adopting the national exhaustion, but if the report says otherwise, we will see later. And I'm really shocked. I'm really shocked, Madam Speaker, because I have in my hand the report of Dr. Ana Maria Paco, study to assess the socio-economic impact of the international exhaustion of trademark rights in Mauritius, funded by the European Union Framework Contract. Extremely interesting reading, Madam Speaker. This lady, who is an academic, came to Mauritius and had meetings with different stakeholders. And she prepared a report, very comprehensive report, where she considered all the arguments pro-national exhaustion, all the arguments pro-international exhaustion. She then considered the socio-economic benefit, the impact on pharmaceutical industry, the impact on textile and clothing industry, on foreign brands, on food and beverages, and on perfumery, cosmetics, very detailed. And this report was submitted in June 2019, last month. Not today, not yesterday, last month, before the bills were introduced in this House. And let me tell you what the recommendation of that lady, that consultant, is. It is at paragraph 15. Recommendation 15.1, exhaustion regime of trademark law. The estimated annual benefit of adopting the international exhaustion regime is close to 1.4 billion rupees. The annual. The estimation made with a short-term partial equilibrium model leaves aside long-term benefit, blah, blah. And then he goes on to say that the majority of the adaptation costs implies an investment that is not repeated, while the social benefit is repeated and increases each year along with the growth of the economy. So a recommendation cannot be clearer. We should get rid of the national exhaustion regime and adopt an international exhaustion regime. This would bring an annual benefit of close to 1.4 billion rupees. Billion rupees in the pocket of the consumers. 1.4 billion rupees which is not going in the pocket of the dealers. So when we already have that report, and that report is very comprehensive, Madam Speaker, it is 79 pages, analyzing sector by sector, cosmetic, pharmaceutical, spare part. She's gone all through, and today we come to the House and do exactly what she has recommended against. Where is the logic? Why? The Honourable Prime Minister say that he's going to follow the recommendation. There's the recommendation, and I'm sure you have a copy of this. And truly, Madam Speaker, there is already in the bill parallel import permitted when it comes to patented article, for example, in section 21, subsection 2. Again, international regime for exhaustion of right with respect to utility model in section 31, 2A. Exhaustion of rights, international regime for exhaustion of right for layout of design, section 47, 2, subsection E. International reserve for exhaustion of rights with respect to industrial design in section 83, subsection A. So whether it is patent, whether it is utility model, whether it is layout design, whether it is industrial design, all of these already have international exhaustion rule, already allows for parallel import, except for trademark. Why? Because trademark is big business in Mauritius. Lots of money. You have to protect the monopolistic situation of the agence d'automobile, of the apparel, of a few, tiny few. That can't be right, Madam Speaker. And it's not too late. It's not too late. All we need is a tiny amendment to section 98, subsection 4, by adding the word or abroad after Mauritius, so that that section would read, the rights conferred by the registration of a mark shall not extend to acts in respect of articles which have been put on the market in Mauritius or abroad by the registered owner or with his consent. So, Madam Speaker, the choice is very clear. If government accedes to the request of the opposition to make this tiny amendment to allow parallel export, the government will be acting for the benefit of the consumers. If the government chooses not to do that, then clearly they will be siding with the private sector, those who have the money to finance political campaigns. Madam Speaker, I will end here by just saying that for me, it is a missed opportunity. This bill is a missed opportunity because we had an opportunity to correct something which ought to have been done since last year. You will recall, Madam Speaker, that last year when the Prime Minister introduced the partial exemption tax system, there was a series of income which was going to be taxed at a preference rate of 3% again, as opposed to 15%. And in the annex to the budget speech, it was announced that the partial tax exemption regime will also be applicable to royalties. So that if you have a trademark owner who assigned its right to a Mauritius company, and that Mauritius company received royalties, that Mauritius company would have paid only 3% tax on the royalties instead of 15%. Unfortunately, I don't know for what reason, this was not in the finance bill of last year. This was not in the finance bill of this year. But surely, if we amend the law, that would be a boost for foreign trademark owners, patent owners, to come and set up in Mauritius. Thank you.